Hi, my name is Tommy Holmes with Holmes Law, PLLC in Houston, Texas. Today we'll be discussing limited liability company operating agreements. Operating agreements are the document which the organizers, officers, and directors may sign, which give the bylaws and other provisions which will govern the company. These are very important because if you do not have an operating agreement in place, or if a provision is not otherwise agreed to, there will fallback provisions that will be in place under the Texas Business and Organizations Code, commonly referred to as TBOC, TBOC. At a minimum, these are the things that you should consider when reviewing your operating agreement and should be in place, especially if an attorney is drafting. For one, it should identify the members and their respective degrees of ownerships and any titles they have. Two, you should state whether the LLC is managed by the members or whether the members elect managers to manage the business. You should describe the capital accounts and the capital contributions of each member at the time of formation. You should describe how the LLC will deal with loans from members and additional contributions that might be sought at later dates. You should discuss and describe how member voting rights and procedures, as well as how meetings will be called. Rights, duties, powers, and any other management roles that members or managers may have should be described in detail. Regular and special meetings, as well as the rights and member voting privileges, should be listed. Compensation, liability, and anything else that should be outlined when you have managers, especially managers of differing degrees, or where you have members acting as managers, should be outlined in great detail to avoid confusion and problems or disputes down the road. You should discuss and describe in detail duties and responsibilities of the tax matter partner or tax matter manager. Similarly, the duties and responsibilities of each officer should be discussed and included in the company agreement. Another thing you should keep mindful of, and is equally as important, is the company's policy regarding allocations and distributions, especially distributions to partners. This is one of the biggest points of contention among partners and LLCs in Texas. For this reason, you should outline how and when distributions will be made. Formulas and other details are helpful. You should also have an outline and policy for keeping books and records, bank accounts, ledger balances, loans, and other accounts which the company is responsible for or otherwise has liabilities to. You should describe how transfers or sales of interest between or among partners or third parties may take place. And lastly, you should consider an outline for procedures in dissolving the company. While this may seem strange to consider at the formation or the operating agreement stage, it's entirely necessary, as in the end, companies will either be bought out, go public, end in litigation, or bankruptcy. In any of these events, you want to have as much procedure in place for such dissolution to make it amicable and as least costly to the partners and all parties involved. As always, should you have any questions or concerns on this matter or any other, please contact us at Holmes Law PLLC via our website, email, or telephone. Thank you.